Day before the first electoral test of 2008, when all eyes are on Iowa, comes a last-minute reminder of just why the election that formally begins tomorrow in Davenport and Sioux City and Winterset and Council Bluffs is so important. Our third story on the countdown, the opening of an official criminal investigation into Waterboarding-Gate, the destruction of the CIA interrogation torture tapes, tapes that included torture that were hidden from the 9/11 Commission, that at least 3 senior White House lawyers knew about and talked about, including the Vice President's current Chief of Staff and the former Attorney General Alberto Gonzales. It is his successor, Michael Mukasey, who today officially announced a full criminal probe into the destruction, recusing the regulars and appointing not a special counsel, but the first Assistant U.S. Attorney John Durham from Connecticut to investigate the case as acting U.S. Attorney for the Eastern District of Virginia. He'll report back to the Department of Justice. The inquiry coming as the chairman and vice chairman of the 9/11 Commission accused the CIA and the White House of deliberately hamstringing their investigation by refusing to disclose the existence of the tapes despite repeated requests for all interrogation material. They wrote a joint op-ed, a Democrat and a Republican, in this morning's New York Times, reading, quote, "As a legal matter, it is not up to us to examine the CIA's failure to disclose the existence of these tapes. That is for others. What we do know is that government officials decided not to inform a lawfully constituted body created by Congress and the President to investigate one of the greatest tragedies to confront this country. We call that obstruction." I'm joined now by Johnathon Turley, constitutional law professor at George Washington University. John, as always, great thanks for your time tonight.
Thanks, Keith.
Mr. Kane, Mr. Hamilton referenced at least one of the possible criminal charges in this case, obstruction, in particular obstruction of justice. What other possible charges should this inquiry be looking into?
Well, it's a considerable list. There's at least 6 that make compelling. There's a compelling basis for at least 6. You've got obstruction of Congress, obstruction of justice. You have perjury, conspiracy, a thing called spoliation. There is also a chance that you might have false statements. So you can. The list gets longer. But the original one is torture. You know, many people in Congress and in the White House and at Justice Department are framing this as an obstruction investigation, as if what's on those tapes is an episode of Barney. What's on those tapes is the original crime in the scandal, and that's the crime of torturing people. It is still, even after the last 7 years, a crime to torture suspects.
How many branches of government could the Department of Justice investigation involve, and could the department limit the investigation to just the CIA or cancel it altogether if it gets too close to the White House?
Well, Keith, that's the problem with the fact that we don't have someone independent. They went out and they selected someone within their own ranks. The investigation will essentially be the Justice Department investigating itself, because on that list of agencies that you are talking about, one of the agencies is likely to be the Justice Department. There's also the CIA, and obviously the White House is involved. The intelligence agencies are involved. The National Intelligence Director's Office is involved. The National Security Council is involved. It's a very considerable list, but you can't ignore the fact that the Justice Department itself is involved.
Does the appointment of this outside prosecutor from Connecticut mitigate that to any degree, or is that dressing, unnecessary dressing here that really should not redound to the Attorney General's credit?
No, it's completely cosmetic. If this was a law firm, this would be like saying that, you know, the Turley law firm has a conflict of interest, so I'm going to have one of my out-of-town offices conducting an investigation. Picking some guy in Connecticut or Cincinnati or Delaware or any other state doesn't make any difference. His boss is Michael Mukasey, and Michael Mukasey's boss is the President of the United States. And if torture occurred, he was the guy who ordered it. So this doesn't help a conflict of interest at all. And so what most of us wanted was someone independent to come in, somebody who was not within this line of this chain of command, to investigate these things independently. But nobody seriously wants that. And I'm not talking about just Republicans. This investigation now involves a range of crimes and a number of people that make it more serious than what originally triggered Watergate. And I can't imagine a case for a better call for a special counsel.
Is there a way the way it's constituted now could still lead to criminal culpability for the president?
Most certainly it can. That original crime could only have been ordered by the president, leads directly to his office. And that's the concern about the Justice Department. They can narrow this, define it in a way to avoid torture. And you've already seen this happen. Play back all the tapes of the leaders in Congress, the White House, and Justice Department, and notice that they rarely use the word torture. And nobody in this town wants to talk about it because they know that there's a lot of people in the country that like the idea of torturing these people. And that's just a painful fact. But it's also a painful fact that it's a crime. And when the president says that we got some useful evidence, I don't know if that's true or not, but it's immaterial. Just because it had good results or good motivations, it remains a crime.
Johnathon Turley of George Washington University with a constitutional fact check of great importance to all of us. Great, thanks, John.
Thanks, Keith.